Hey, you lovely lot, and welcome to Crime Analyst and the Intelligence Cell. Now, today I wanted to give you an update in the case against Colin Pitchfork. And this is an important one. We have all played a role in ensuring that Colin Pitchfork remains in prison for now. And I just want to thank you all for taking the time to watch Crime Analyst on YouTube and me talk about the case, but also taking the time to actually write to the Lord Chancellor and Justice Secretary Alex Chalk. So thank you so much. And I want to give you an update today because I've received a letter that I want to tell you about. Okay, so before I read sections of this and give my thoughts and analysis on it, I also just want to say thank you so much for subscribing to Crime Analyst YouTube and for watching my videos. And if you haven't subscribed just yet, what are you waiting for? Click the button to subscribe so you don't miss out on future content. Okay, so it's been a really long week. There's been lots of cases happening, but this is an important one. And I want to share with you a letter that I received from His Majesty's Prison and Probation Service in reply to my multiple communications about the case and about the flawed, what I believe is a flawed assessment in this case. So do watch my previous YouTube video on it because I'm not going to go into all the detail of what happened. This is really an update. So first of all, the letter starts off saying that they can't provide me with specific details about Colin Pitchfork's case. They will address my concerns about the Parole Board's recent direction. So I'm just going to read some of the paragraphs from it. So it says, it may be helpful if I explain that the sentence imposed by the court reflects the need to protect the public, punish the offender fairly and appropriately, encourage them to make amends for their crime and contribute to stopping reoffending and cutting crime. There is no power for the Ministry of Justice ministers or officials to intervene in sentences handed down by the courts, which are independent from government. Having been given a sentence by the court, prisoners may be released only in accordance with legislation laid down by Parliament. I should emphasise that it is already the case that a whole life order is a starting point for the murder of two or more people, whether adults or children, where each involves either premeditation, abduction, or sexual or sadistic conduct, and the starting point for the murder of a child involving abduction of the child or sexual or sadistic motivation. These starting points were first set out in the Criminal Justice Act 2003 and have now been included in the Sentencing Act 2020. However, Colin Pitchfork was sentenced in 1988 for his appalling crimes, well before these provisions were put in place. They therefore could not apply to this case and could not now be made to apply retrospectively, as this would amount to the retrospective imposition of a heavier penalty and would likely contravene Article 7 of the European Convention on Human Rights. So that's important because this case, Colin Pitchfork, ticks all of those boxes. So as I said before, he would most likely get probably 2 whole life tariffs, which would mean that he wouldn't be released. But they're saying that they can't apply this retrospectively. Okay, so that's a problem, particularly when you're talking about someone like this. But the letter continues. It is for the Parole Board to assess whether the risk presented by a prisoner serving a life sentence can be safely managed in the community on licence once their tariff has expired. The Parole Board will consider all the available evidence, including the circumstances of the offences and any progress which the prisoner has made in custody, in order to assess their risk of causing harm. The Board conducts a thorough assessment of the prisoner's current risk, taking account of a wide range of reports from qualified staff. Where a panel of the Parole Board directs the release or re-release of a prisoner serving a life sentence, it does not mean that the panel has concluded that the prisoner now represents no risk to the public or specified individuals. Rather, the panel considers that the prisoner's risks may be effectively managed in the community using the controls and licence conditions which the Probation Service has presented to the panel in the form of a risk management plan. Following his most recent review, the Parole Board decided that it is no longer necessary for the protection of the public that Colin Pitchfork remains detained, and so directed his release on licence. Okay, so it's basically saying that he can be managed with provisions, with various conditions placed on him in the public domain, so in amongst all of us. That's why they've made that decision, which obviously I take issue with, but I'm going to come on to that in a bit more detail in a minute. So the letter continues. As with other release decisions in the case of life sentence and other parole-eligible prisoners, and in accordance with the statutory Parole Board rules, the release decision in the case of Pitchfork was provisional to allow officials on behalf of the Secretary of State to consider whether there were grounds to ask the Parole Board to reconsider the decision. For a reconsideration application to be submitted, there must be an arguable case that the Parole Board failed to consider properly the case either procedurally or substantively, which may have led to a mistake in the assessment. The threshold is similar to that of a judicial review, and there must be evidence of the decision containing an error in law or being either procedurally unfair or irrational, brackets in the legal sense. Okay, so this is interesting, saying that the release decision was provisional to allow officials on behalf of the Secretary of State to consider whether there were grounds to ask the Parole Board to reconsider the decision. So it was provisional. It wasn't a fait accompli, and that application was submitted. And that was submitted because of our collective voices. So thank you so much to everybody who wrote to the Secretary of State to ensure that he understood how the public felt about this decision. And public protection is a really key element here. So the letter continues, after a full consideration of the decision by officials, we were satisfied that there were sufficient grounds for a reconsideration application to be made. And on the 5th of July, made such an application to the Parole Board. Okay, so that's great. A Parole Board member who was not involved in any way in the provisional release decision will review that decision in the light of the points made in the reconsideration application. Where the Parole Board member accepts the application, they will issue directions as to how the Parole Board will review the case again. Until such time as that review has been completed, Colin Pitchfork will remain in prison. Great, that's good that he remains in prison. So we don't know how long this review might take, we don't know the detail of the review, and we don't know how long this process will carry on for. So the terms of reference, really important. But what the letter says is there's no guarantee that the original decision will be changed, but it will be thoroughly reviewed. However, if the Parole Board member rejects the application, the release decision becomes final, and His Majesty's Prison and Probation Service will, by law, be required to release Pitchfork on licence. So I really hope that this Parole Board member understands psychopathy, and it's not possible to rehabilitate and treat someone who has psychopathy and render them safe. That, for me, was a key flaw in the risk assessment that they had conducted. So he may say all the right things, he might look like he's doing the right things, but it's chameleon-esque behaviour, mirroring back and saying what they want to hear and know. So I'm going to continue on. I would like to assure you that a prisoner serving a life sentence will be subject to a series of standard licence conditions upon their release, as well as further additional conditions to mitigate the particular risks they pose. They might include a condition to reside as directed by their supervising officer, a condition to undertake further risk reduction work, considered necessary, a no-contact condition and an exclusion zone prohibiting the offender from entering areas where the victims live, work or travel to frequently. They will be managed by a qualified probation officer from the probation service. The probation service also work closely with the police under the statutory multi-agency public protection arrangements, MAPA, to monitor the offender in the community. Should an offender breach the conditions of their licence in such a way as to show evidence of increased risk, they may be recalled to custody should the probation service conclude that they may no longer be safely managed in the community. Okay, well, I know all of that, and the problem that I have is that there are a number of cases, like Janet Scott, where a prisoner was released, and in this case it was Simon Mellor, where he had already killed Pearl Black, and he then started a relationship with Janet Scott, and he abused her, and he threatened her, and he stalked her, and she reported him to police, and she called the probation service, and he was not recalled. And he escalated and murdered Janet. The case of Zara Alina, where Jordan McSweeney was released when he shouldn't have been, and he immediately went looking for a woman, and unfortunately he found Zara walking home one night, and he sexually assaulted her, having stalked her, and murdered her. So there are, unfortunately, many cases where there has been failure. And no probation officer, and having trained thousands of probation officers, it's just not possible to monitor someone 24/7. And someone like Pitchfork will bide his time and will wait, and he will ensure that he offends in a way that he will not be identified. And that should give everybody chills. He is a psychopath. This is need-driven behaviour. The probation service is strapped for resources and in terms of staff and experienced staff. So with the best will in the world, it's just not possible to manage somebody like Colin Pitchfork. And it is far too risky. And I'm all about intervention and prevention and learning the lessons. Why should another girl or woman be brutally murdered by him? Why should another family be ripped apart? These lessons to be learned that never are. That's what causes me the most concern here. Learn the lessons of the past. Why make this decision? So the letter continues. We're reforming the parole system to ensure public protection is at the forefront of all parole decisions so that victims and the public can have greater confidence in the system. Well, that's great. For me, the litmus test is whoever this parole board member is and the parole board who made the determination to release him, would they feel comfortable and confident releasing Colin Pitchfork to live next door to them if they had daughters? Would they feel confident? That's the litmus test. And if it's a no, then that tells you he should not be released. But the point is, with psychopathy, they cannot be treated unless they found some magic cure. And let's not forget his psychosexual pathology. So this is a serial perpetrator, a serial killer, and it's really important that that's understood. For the families of Linda Mann and Dawn Ashworth, this is just agonising as a process. So what's said next in the letter is important. We will change the release test so that no dangerous offender is released unless it's clear they no longer present a serious risk to the public. And we will legislate to give ministers the power to refuse a release decision made by the parole board if they disagree that the release test has been met. Public protection is a top priority, which is why we are toughening up the parole system through our package of reforms designed to restore public confidence and put victims and public protection front and centre of the process. We will change the release test so that prisoners who still pose a risk are kept behind bars and introduce a new ministerial veto to keep the most dangerous offenders off our streets for longer. Good. I'm really pleased to hear that. And there has been the Victims and Prisoners Bill going through Parliament, which gives the minister the veto, the ability to overrule the parole board. And for me, it's really important. There are lots of people who say, oh, it's not required. But yes, it is. In cases like this, it is required. It is really important because we don't have really the experience that's required on all the parole boards. And there is a need for greater, for more professionals with law enforcement backgrounds so that professionals who understand psychopathy and understand dangerous perpetrators are on those parole boards and making these decisions. And as I kept saying in my BBC interview, has he been assessed as a psychopath? Because that changes everything. That PCLR assessment, the psychopathy checklist assessment, because the offenders are chameleon-esque, they mimic emotion, they are pathological liars, they are grade A manipulators, they cannot be believed or trusted in what they say. And you can put 40 conditions on them and they will find a way because this is their tradecraft, it's what they do. They live it, they breathe it, it's need-driven behaviour, and it is too risky a decision to release them. And if released, well, where's the accountability when something goes wrong? Because it will. So who are those professionals in that chain of accountability? Because transparency is also very important with these decisions. So who's making these decisions? And I don't want to hear, oh, sorry, we will learn the lessons when it all goes horribly wrong, because Zara's case, Janet Scott's, how many more cases do we need? I'm really glad that the parole system is being reviewed, and also to hear about the ministerial veto. I knew that that was in the background. So there is another fail-safe, a contingency plan in this case. So the letter ends with, thank you for writing to us about this important matter. I appreciate your concern regarding this matter and hope that this response provides assurance that the Parole Board's decision to direct the re-release of Colin Pitchfork is being reviewed. Yes, it does provide that. I would like to know the terms of reference for that and the timeline for that, of course, but I will certainly keep you all updated. So I'm going to end there and keep it short and sweet. I want us to think about Linda Mann and Dawn Ashworth and their families. Really important for them in this process to have trust and confidence. And thank you all so much for watching and also for writing to the Lord Chancellor, and I'll let you know what comes next. Until next time, be curious, ask questions, and always trust your instinct.